Testing. Can you all hear me clearly? Yeah. Okay. Okay. Good morning, ladies and gentlemen. Thank you very much for joining us. This financial fraud analytics. This morning, we are going to talk about anti-money laundering and counter-terrorist financing. Is there any problem?
You open the Zoom in the in-class, right?
Yeah.
Because last time your recording, it seems failed.
Okay, can you check? Okay, so let us begin. Today we are going to talk about the best practice and the compliance issue in relation to anti-money laundering and counter-terrorist financing. Let us have a look at the agenda today. We're going to start with the overview and key concepts of money laundering and terrorist financing. And we are going to talk about the international best practice, i.e. the FATF recommendation, which is the international standard. And then we are going to talk about the AML-CFT legislation and regulation in Hong Kong. And I'm going to talk about the law as well as the guideline. The law is a bit dry, but I'll try to restrict it to a shorter framework. And then I'm going to tell you the key requirement and the best practice, including the risk-based approach, customer due diligence, ongoing monitoring, recording and retention of records, recognition of suspicious transaction, as well as staff training. These are key as well as the basic requirement of a proper anti-money laundering and counter-terrorist financing framework. And then I'm going to share with you some of the latest enforcement cases in Hong Kong, focusing on the SFC areas. And then in our next lecture, we are going to talk more about the HKMA, Hong Kong Monetary Authority cases. And in any event, HKMA and SFC have similar guidelines, so don't worry about it. Okay. The plan is that I'm going to do the lecture, and I'm going to give you a case study so that you can work together with your team members. And I would suggest that you group together with people, the other students around you, and then you work on the case study together based on what you have learned in class, right? So just to test your understanding of the requirement. And in any event, in say final exam, you may be asked to do a case study in order to ensure that you have a proper understanding of the requirement of AML and the practical side of applying the AML and CFT requirements in the real life, right? So that's the plan for today. Let us have a look at the key concepts, right? Is it working? Yeah, it's working. It's working. Yep. So let's have a look at the key concepts, right? What is money laundering? Basically, it covers all kinds of methods used to change the identity of illegally obtained money so that it appears to have originated from a legitimate source, right? So basically, you are changing it from one nature to another nature, but actually nothing has happened. The only process that has been done is the criminal to use a process which is called money laundering to look as if the money has generated from a legitimate source, right? So the original process is dirty process, i.e. obtained from crime, from money laundering, from say drug trafficking, from tax evasion, all sorts of criminal offenses, right? So it is dirty money. And in any event, by using the money laundering process, it would appear that the money was generated from a legitimate source, but it wasn't. It wasn't, right? It is a process to cover the source of dirty money, right? So that's money laundering. And the stages in money laundering, there are 3 common stages in money laundering: placement, layering, and integration. You have to learn these. It is basic, right? Anyone working in a bank or have worked in a bank, financial institution, or regulated industry have learned anti-money laundering before? Anyone? None? Okay, yeah. And because people working in a bank has to learn, in a bank, in regulated industry, they have to learn anti-money laundering at least once a year and need to go through examination. But their understanding is more basic, and your seminar here today is more comprehensive, and you would understand more in depth in terms of the key concepts, as well as how to use it in real life, right? So placement is the physical disposal of cash process derived from illegally obtained money, i.e. it is the physical disposal of cash process derived from illegal activities. That is called placement. And then layering. Layering is the separation of illicit process from their source by creating complex layers of financial transactions. Basically, criminals use the dirty process and then they create complex layer, such as, say, placing the money in a bank is called placement, i.e. deposit the money in a bank is called placement. And in terms of layering, say, for example, place the money in a bank and then buy some securities, right? Or exchange it to other currencies, then that is called layering, i.e. create complex layers of transactions, right? And then integration, returning the laundered process back to the financial system so that the process appear to have a legitimate source, right? Say, for example, you easily can see that a number of restaurants could be starting for a few months and then they close down. Some businesses, especially those cash-intensive businesses, they started and then closed down in a few months' time. Why did they do that? Why did they do that? Because they want to, say, transfer the dirty money into real business and then cleanse the money so that people will see that the money is clean. And then once the money is cleansed, then they will be, say, transforming the dirty money to clean money, i.e. it looks as if the money is clean money, right? Say, for example, people may, say, become a partner in a restaurant. They may open a new restaurant. They may become a partner in a restaurant, deposit the money in the restaurant, right, as capital, and then mix the money with the daily cash income, right? Say, for example, you go to a restaurant, you will pay money, right? You have dim sum, and then you will pay money, right? The money is income of the restaurant, right? But on the other hand, some criminals, they may deposit money in a restaurant and then mix it with the daily income. And then the dirty money is mixed with the clean money. And then this is the way that they can cleanse the dirty money. And it looks as if it is, the money is part of the income, right? Okay, so this is one of the ways that they will do it. Other cash intensive industry, say for example, buying and selling, say diamond, i.e. Diamond trader, and say for example, travel agencies, right? When you go to travel agency, you can say use your credit card, but some people may pay cash. And also say travel agents, when they travel overseas, they will say exchange a lot of money, right? They will hold a lot of cash, right? They may deliver some cash from overseas to Hong Kong and then deposit it into a financial institution, say for example, a bank, so for example, a brokerage house, for example, an exchange house, right? So this is where the concern is, right? Because dirty money can be mixed with clean money, integration of dirty money back to the financial system. So these three stages you must know, right? Placement, layering, and integration, okay? And very often when we talk about anti-money laundering, we will also talk about terrorist financing, right? Some people mix the two, right? Actually, it's quite similar, but on the other hand, it's different, right? In terms of money laundering, we are talking about dirty money, right? But in terms of terrorist financing, it could be dirty money, could be clean money. Why is that? Have you heard about the 9/11 incident? You may be too young, right? Too young to know that, right? The 9/11 incident is 20 years ago. 20 years ago, the Muslim terrorist bombed the World Trade Center in the United States, and thousands of people were killed, right? And the US government were very angry, and the whole world was astonished to see that. And everyone was so concerned in terms of terrorist attack, right? And the question is, where does the money come from? How do we control the terrorists, right? And so, thorough investigation was conducted by the US government and the Financial Action Task Force, right? And the key is to find out what happened, how can we control it, right? And then some people mentioned it must be money laundering. It must be money laundering, i.e. dirty money used to do the terrorist attack, right? But unfortunately, the investigation found out that most of the money that was used to do the terrorist attack was clean money. It's clean money, right? It's clean money. So the US government cannot sue those terrorists by using anti-money laundering law and regulation, right? So that's why terrorist financing come up, right? Because terrorist financing, we are talking about dirty money as well as clean money, right? Because the investigation was very thorough. It also told us that a lot of the money was generated from donation, especially from the Muslim churches, right? So donation, when we talk about donation, we donate money from where? Are they clean money or dirty money? It's clean money, right? Right? I earn my salary and I donate to the church, right? That's clean money, right? So that's why money laundering law and regulation cannot combat this, and we need terrorist financing, regulation, and law, right? And that's why we have the terrorist financing regulation. In the simple terms, terrorist financing refers to financial support in any shape or form of terrorism, or to those who encourage, plan, or engage in terrorism. So if you work in a bank, someone come to your bank to open an account to deposit the money, right? Before the money was deposited to your bank, you have to do the customer due diligence. You need to understand who this customer is, right? And what is the background of the customer, the source of fund, the source of wealth, right? If the customer bought say a large amount of cash, then you really need to be careful, right? And so if a terrorist come to your bank to open an account, and then you help the terrorist to say transfer the money from one form to another, i.e. say, for example, from Hong Kong dollar to US dollar, from US dollar to British pound, then you are helping the terrorists, right? You are assisting the terrorists. You encourage, plan, or engage. You provide financial support to the terrorists who encourage, plan, or engage in terrorism. So in that circumstances, that you will be caught, right? So it is very important for us to understand, right, terrorist financing and money laundering. Money laundering refer to dirty money, while terrorist financing refer to clean money as well as dirty money, right? The key concept is that. Any question before we move on? If not, then let me introduce the Financial Action Task Force. Basically, it is an intergovernment body established in 1989. The objective is to set up international standards in terms of money laundering and terrorist financing, and work together within the different countries, the government, to combat money laundering and terrorist financing. The FATF has issued the 40 recommendations. And if you are interested, you can go to the website of FATF, and there are different versions of recommendation, and they are updating this recommendation on a regular basis. The key requirement of the FATF is that all countries should have law and regulation in relation to customer due diligence, politically exposed persons, high-risk countries. I'm going to explain each of these concepts shortly. Record-keeping requirement and reporting of suspicious transactions and tipping off and confidentiality. So these are the key recommendations for the countries all around the world. Sorry? It's not clear. Not clear. Okay, and in terms of the recommendation, apart from bank, brokerages, asset management company, as well as other regulated industries, the FATF recommended that DNFPP. What is that? Designated non-financial businesses and professions, such as real estate agent, casino, dealers in precious metal, dealers in precious stone, diamond trader, right? And jewelry shop, lawyers, accountants, and other professionals, as well as trust and company service providers. They need to follow the requirement of the FATF in relation to anti-money laundering and counter-terrorist financing, right? So if any of you or any of your friend is working in this industry, they will be regulated in any event in different parts of the world. So once you have learned this anti-money laundering and counter-terrorist financing requirement, it applies to every country. Basically, you go to US, UK, Singapore, Japan, any part of the world, they are using this FATF recommendations, right? And so once you have learned that, you will have the key concept and you will have the basic understanding of anti-money laundering and counter-terrorist financing. And the only difference is that the law may be, the name of the law may be different in Hong Kong as compared to UK or US, right? But the ingredient is the same. They follow the FATF recommendation. Say, for example, in China, we are also following the FATF requirement. Say, for example, the law in China is a bit different from Hong Kong. Say, for example, in terms of Hong Kong, we have suspicious transaction reporting. And in terms of China, there is also additional large value transaction reporting as well, right? That's some of the minor differences. But the key concept, the key ingredient is the same all over the world, right? So once you have learned this, you go to other countries, it will be similar, right? So it is important for you to learn and understand the concepts, right? Now, the FATF has also issued the statement on high-risk jurisdiction. And you may call this the blacklist, right? And the blacklist, who are on the blacklist currently, i.e. the latest one is June 2023, and there are 3 countries. One is DPRK, which is also called North Korea, right? North Korea, right? Democratic People's Republic of Korea. Basically, the issue is that they have ongoing and substantial money laundering, terrorist financing, weapon of mass destruction, as well as proliferation financing risk. And the FATF would recommend countermeasures and targeted financial sanction on customers coming from these countries, right? And so if you work in a bank or brokerage or in other regulated industries, you would need to understand clients or customers from these countries. You need to really take special attention because you are supposed to ensure that countermeasures is imposed. And basically, you should not be working or having business relationship with, say, clients from North Korea, right? And apart from that, Iran has not completed the action that they have promised FATF long time ago. They promised to address their strategic deficiencies. However, they have not dealt with that. And the FATF has decided that countermeasure has to be imposed on Iran, right? And Myanmar has got strategic deficiency and it is not progressing. So it is not as serious as North Korea and Iran, but the thing is FATF also put it in the blacklist. And if you want to, say, work with customers from Myanmar, you have to apply enhanced customer due diligence, right? And enhanced customer due diligence is above average requirement, i.e. normal customer, you use customer due diligence measures, i.e. you do the standard checking and investigation in terms of the client. But in terms of, say, customers coming from Myanmar, you have to impose enhanced customer due diligence, i.e. you need to check really, really careful and in-depth and as well as additional measures, additional work need to be performed in order to accept this particular client, right? And you also need to get senior management approval before you get this client on board, right? And in any event, these three are on the blacklist, right? i.e. they are the highest risk. Let's have a look at the grade list, right? The grade list is that these countries, they have strategic deficiencies. And the thing is, they are committed to resolve these deficiencies quickly, right? And they have deadline to agree with the FATF, right? So the FATF put them in the grade list. What countries are we talking about? Albania, Barbados, Cameroon, Cayman Islands, right? Jamaica, Jordan, Nigeria, Philippines, South Africa, South Sudan, Syria, UAE, Vietnam, right? And Yemen, they are on the grade list, right? So the point is that these jurisdictions, they are under increased monitoring. You need to monitor closely these clients. And in terms of clients coming from these countries, you need to do additional work to make sure that you understand their background, to understand where the source of fund and the source of wealth, etc., right? And so, as I mentioned before, there are issues that you need to do, i.e. issues that you need to resolve. Say, for example, this is in relation to country risk, right? Country risk is only one of the risk factor that you need to handle. And a few years ago, there was a complaint to the HKMA, the Hong Kong Monetary Authority, in relation to the Filipino maids in Hong Kong are unable to, say, open the bank account in Hong Kong, right? So they complained to the Hong Kong government, and they said that, wow, because a lot of the banks say that they are from the Philippines, which is on the grade list. So they are refused to open a bank account, right? So the HKMA has issued a circular to all banks and advising them that country risk is only one of the risks, right? In terms of Filipino maid, although Philippines is on the grade list, but on the other hand, apart from looking at the country risk, you also need to look at the customer risk, right? You need to understand the background of the customer. If it is a Filipino maid, they have proper contract to work in Hong Kong, and they have, say, proper employers, they have a monthly salary, and what is the purpose of opening the bank account? Say, if the bank account is only going to be used to, say, transfer the money back to Philippines, it makes sense. It would be considered as acceptable normal risk rather than a customer that you need to, say, reject, right? So there are a number of things that you need to consider. Country risk is one of them. And we are going to talk about the other risks shortly. Now, the FATF is a bit concerned in terms of the beneficial ownership of companies, because quite a lot of the criminals, they are using companies to, say, launder illegally obtain money, right? And say, for example, they are using lawyers, CPA, and service providers. Say, for example, using directors as front person to do, say, drug trafficking, to do, say, human trafficking, tax evasion, etc., right? So they want to ensure that this is tightened. Now, why are they so concerned in terms of beneficial owner? Because beneficial owner is the natural person, the real person. who ultimately owns or control the company, right? So when we are talking about, say, companies from, say, BVI, Cayman Islands, right, all these tax haven, we will need to check the ultimate beneficial owner, right? Say the shareholder may be another 2 corporations, but at the end of the day, you need to know the ultimate beneficial owner. At the end, who control the company? Who is the mastermind of the company, right? So you need to verify the beneficial owner's identity. And there are a number of requirements the FATF want each country to, say, impose, right? So the latest beneficial ownership requirement is to have tighter global beneficial ownership rules to stop criminals from, say, hiding their dirty money, right? And apart from that, the FATF also require greater transparency regarding ultimate ownership and control, right? And then making sure that all the government are going to work together closely on this. And that's why, say, for example, in terms of Hong Kong, we have a register showing all the ultimate beneficial owner of a company, and that has to be kept by the company at their registered address and also provided to the company's registry, right? So these are some of the requirements to comply with the FATF beneficial ownership updates, right? And so that's why the information has to be available to competent authorities. Competent authorities, i.e. government department, say, for example, in Hong Kong is the company's registry. Okay, so we have talked about the law and requirement, right? Let us go through the law one by one, right? Now, the Drug Trafficking Recovery Process Ordinance, the Organized and Serious Crimes Ordinance, these are the oldest law in Hong Kong regarding AML and CFT, right? It applies to everyone in Hong Kong, every company in Hong Kong, right? The same also apply to United Nations anti-terrorism measures, right? It applies to everyone, every country in Hong Kong. And the same for United Nations Sanction Ordinance, Weapons of Mass Destruction Control or Provision of Services Ordinance. These apply to everyone and every country, every corporation in Hong Kong. On the other hand, you will see that the AMLO, the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, it does not apply to every corporation, everyone in Hong Kong. It only applies to banks, financial institutions, and regulated industries. And on the other hand, this regulated industry and the scope is expanding. It has been extending to other businesses and professions, right? As we briefly mentioned earlier. So this law is a bit different, and we are going to cover that in greater length shortly. And because of the law, there are regulations, guidelines provided by the various government departments and authorities. Say, for example, the Securities and Futures Commission is responsible for regulating brokerages, security house, asset management company, as well as virtual assets, right, currently. And the HKMA basically is regulating the banks and other, say, regulated industries setting out in the HKMA regulation. And insurance authority, it applies to insurance company, insurance agent. And also the Customs and Excise Department and the company's registry are also involved in terms of the supervisor or regulator of the law and the regulation in relation to AML and CFT in the different regulated industry. Let us have a look at each of them. Now, I want to quickly go through the law. This is very basic and easy to understand. The Drug Trafficking and Recovery Process Ordinance, subject to 25(1) of this law, a person commits an offense if he has reasonable grounds to believe that it represents process of drug trafficking, i.e. has the mens rea, right? Has the understanding, and the thing is reasonable grounds to believe, right? That the process before you is drug trafficking process, right? He deals with the property. He actually helps in terms of the transfer or the arrangement of the procedures, then he commits an offense. And it seems quite scary, right? Say people working in a bank, if a customer brings a lot of cash to the counter and the officer deals with the property, i.e. deposit the money in the bank account, then he commits an offense. That's very scary, right? Easily caught, right? Don't worry too much about this, because what he needs to do is to disclose the suspicion to the authorized officer as soon as it is reasonable for him to do so, right? And so once he has disclosed that knowledge or that suspicion, then he is immune. He will not need to go into jail, right? And so the concept is reasonable grounds to believe, right? And then he deals with the property, then he commits an offense. What he needs to do is to disclose that knowledge or that suspicion, right? Another law, organized and serious crime, is the same as the other one. It's the same, right? Basically, Drug Trafficking and Recovery Process Ordinance and the Organized and Serious Crimes Ordinance is exactly the same. The difference is that organized and serious crimes include murder, kidnapping, drug trafficking, robbery, false accounting, bribery, etc. It's wider, right? So basically it is the same, but the thing is what you need to do is to disclose that knowledge or suspicion to the government. Then in Hong Kong is the JFIU, right? Then that should be fine, right? So it applies to everyone, no matter whether you work in a bank or not, right? Because in some of my students, they said, well, if I don't work in a bank, I don't need to know anti-money laundering. That's wrong. Everyone in Hong Kong needs to know, and you will be caught if you say violate any of the regulation, right? The only difference is the AMLO. The AMLO only apply to financial institutions and regulated industry, right? Because it is very strict in terms of the requirement. We are going to talk about that shortly, right? Now, another one is the United Nations Anti-Terrorism Measures Ordinance. Basically, it is an offense if you provide or collect funds with intention or knowing or having reasonable grounds to believe that the funds has been used or will be used to commit one or more terrorist activities, or make funds or financial services available to terrorists or terrorist associates. So the important thing is, say, if you work in a bank or you work in an, say, fund house, or work in an asset management company or a securities company, right? If you, say, provide funding to the client, right, then you might be caught by Section 8, right? If you provide or collect funds, the important and key words is with intention or knowing or having reasonable grounds to believe that the funds will be used to commit terrorist activities, then you might be caught. Okay, so need to be very careful, especially if you work in the financial industry. Now, is it an offense to deal with drug trafficking the process of drug trafficking? Is it an indictable offense? Yes or no? Yes, right? Yes, right? The highest penalty is 14 years imprisonment and a fine of 5 million. And that's very substantial, right? While I work in the SFC and if anyone working in a bank or a regulated industry, if he or she is caught in terms of breaching the money laundering regulation or the law, they will not be able to continue working in the industry, right? Because the regulator will confiscate the license or to suspend the license, right? So it is a very serious offense. Is it an offense to provide financial services to terrorists or their associate? Yes, right? The highest penalty is imprisonment for 14 years and a fine, right? So it's similar. Is it a must to report suspicious transaction? Yes. If you fail to do that, the penalty is 3 months imprisonment and a fine of 50,000. Can I inform my client after submitting a suspicious transaction report? You better not. You better not, right? Because the maximum penalty is imprisonment for 3 years and a fine. Do you understand why you might be, say, put into prison if you tip off a client? Because the regulation clearly says out that you cannot tip off your client. Because at the end of the day, the regulators will investigate the suspected money laundering or terrorist financing cases, right? And they need to trace the funds of the money laundering. The most important thing is they want to, say, confiscate the money or the assets of the money launderer or the terrorists, right? So if you tip off this particular person and tell them that, oh, it seems that you are a money launderer, right? Then the client immediate response is very angry, right? Or if the client is actually a money launderer, they'll say, fine, no problem, transfer my money to BVI, this particular company. Now, immediately, right? Once the money is transferred out of Hong Kong, you won't be able to get it back, right? And the government will not be able to confiscate the money and the assets and won't be able to investigate further, right? So it would be very difficult, right, to combat money laundering and terrorist financing. And that's why you should not tip off your client and you need to report suspicious transaction, right? I on a regular basis work on money laundering cases, and I help the Department of Justice in terms of doing money laundering prosecution. And basically, being an accountant and a former regulator, I was often asked to, say, help the prosecution in preparing a fund tracing report, right? Because the thing is, if you can trace the flow of the funds from the destination to the source, right? i.e., if a money launderer or a suspected money launderer has got a house in mid-levels, has got a yacht, has got a Ferrari, right? Has got a substantial amount of money in the bank account, the prosecution would want to trace the money from the destination to the source, right? Where did the money come from, say, in terms of buying this particular Ferrari, from which bank account, and then where does the money came from, right? Tracing from one bank account to another bank account, from one contract to another contract, in order to trace the source. If the prosecution can trace the source back to the original dirty money, i.e. the money was derived from drug trafficking or tax evasion or say organized crime, then the prosecution can apply to the court to confiscate the assets of the criminals, right? So it is very important for you to say report suspicious transaction and also making sure that you won't tip off, right? What are the penalties imposed under the AMLO? Now we talk about the AMLO, right? The AMLO, the Anti-Money Laundering Ordinance, right? At first, when it was set up, it applies to banks, brokerages, asset management company, and any company regulated by the SFC and the HKMA, and that's it. And then it is extended to insurance company and other regulated industry. The importance of the AMLO is that it imposes an obligation on the company and also on the staff, the employee, making sure that they are complying with the law in terms of CDD and record keeping. CDD is customer due diligence, right? You need to understand who your client is, right? Their background, their source of funds, source of wealth, and you need to have the supporting documentation recorded, right? Keeping the record of the background and the customer due diligence work that you have done, and ensure that when the investigator or the regulator come to your office, you will be able to provide the information immediately, right? And this is the requirement. And a lot of companies, although there were suspicions of potential money laundering or terrorist financing, but there were insufficient grounds to pursue the money launderer or the terrorists. But on the other hand, the regulators impose fines on the banks and the brokerages in terms of violation of CDD and record keeping. The reason is that because the regulated industry failed to do proper CDD and failed to properly record the documents required for investigation. That's why the regulators were unable to investigate and trace the source of funds of the criminals, right? And so they are penalized, right? So two sanctions. One is criminal sanction, both on the financial institution as well as the employee, right? If a financial institution or employee knowingly contravene either CDD or record keeping, then it commits an offense. The financial institution or the person commits an offense is liable on conviction, on indictment, a fine of 1 million and imprisonment of 2 years. If the financial institution or an employee with intent to defraud, right, with intent to defraud any regulator, then the fine is 1 million and the imprisonment is 7 years. That's a serious offense, right? And the civil sanction is that the regulated industry party would be disciplined, such as reprimand by the regulator, by SFC, by HKMA, right? Or a fine. However, the government understand that sometimes the employee is put into jail. It is a bit unfair if the company did not have proper policies and procedures, right? So it is a defense for the employee if the company did not have proper policies and procedures, right? So say, for example, if the company did not have policies and procedures telling the staff what to do in terms of CDD, what to do in terms of record keeping, then the penalty will be imposed on the company, the financial institution, instead of the employee. But on the other hand, if the company has got very comprehensive policies and procedures for the employees, but the employee failed to follow, then the penalty will be on the employee, right? So quite a lot of people say that, wow, it's a bit risky to work in the financial industry or the regulated industry, right? Well, Hong Kong is a financial center, right? So a lot of people working in the financial industry, right? So in any event, the AMLO has been extended to other regulated industry as well. So in any event, it is important to follow the law and the regulation, right? Now, one question, if the company has got comprehensive policies and procedures, and on the other hand, the employees say that, well, we are not aware of the policies and procedures because the company has prepared the manual, but has not been properly communicated and dispatched to the employees. Who is in default? If you are the regulator, are you going to penalize the company or penalize the employee? Now, the company has got a very comprehensive policies and procedures in terms of money laundering and counter-terrorist financing. But on the other hand, the employee is not aware of that because the company has not properly dispatched the policies and procedure and did not provide proper training to the staff for them to understand that CDD and record keeping is very important. If you do not follow, you will be penalized personally and you would be put into jail if it was found by, say, regulators. Now that you are the regulator, who will you penalize? The company or the employees? Think about it. Who think that the company should be penalized? Raise your hand. 1, 2, 3, 4, 5, 6, 7, 8. Okay. What about the rest? You believe that the employee should be penalized, right? Okay, so why do we think that the company should be penalized? Anyone? Anyone want to tell us the answer? Anyone? You want to tell us? What's your name? Zhao. Zhao. Thank you.
Well, I worked in a company. I have to do some tests. I must pass some examinations for those questions. So if the company not do these operations, I think that is a company's problem. Yeah.
Okay, That's a very good answer. And what sort of company do you work in? Oh, Ali, okay. A payment, payment operator. Okay. Yep. Because payment operator is also one of the entities regulated by the HKMA, right? And payment operator is similar to a bank, but the function is a bit different. And so it is also regulated by HKMA. They need to have a license, right? To obtain it from the HKMA. And that's why they also need to comply. So Chow told us that basically the company will need to be penalized because although they have very good policies and procedure, but on the other hand, they did not properly communicate to the employees, right? So the employees do not know exactly what is required, right? So they would have a good defense in terms of the penalty, right? So the thing is, the company will be penalized, but not the employee, right? Okay, shall we take a break of 10 minutes and then we'll continue? Thank you. 10 minutes break. Thank you. Okay, ladies and gentlemen, let us resume. Now, we have talked about the law, and basically the regulators, they issued guidelines to help the regulated industry to comply with the law. And as I mentioned before, there are some key requirements. Say, for example, the risk-based approach, customer due diligence, ongoing monitoring, suspicious transaction reporting, record keeping, and staff training. These are the key requirements. So every regulated industry must comply with these core areas, right? And what about if they don't follow? If they don't follow, the SFC or the HKMA or the regulators can use these evidence to show the court if there are any legal proceedings, right? So, and at the end of the day, it is important to follow the regulation. And even though there are guidelines, regulated industry must comply, right? Okay. Let's move on. Okay, now we talk about the different risk, right? Risk-based approach, i.e. higher risk, we will use more work, i.e. risk-based approach. High risk, we do more work. Lower risk, we do less work. And the extent will depend on the background, will depend on the product, etc. So the four areas that you must know is country risk that we have learned, right? The gray list, the black list, right? If they are on these two lists, you would need to regard that as higher than normal risk, right? And then the customer risk, right? Who is that particular customer? Is the customer a politically exposed person? Politically exposed person in detail, the key concept, I'm going to talk about that shortly. So if basically a politically exposed person refer to senior government official who might be, say, using government funds to do some of the laundering approaches or drug trafficking or other illegal activities, right? And product risk, depending on the type of product that you provide to the clients, and delivery channel. How do you deliver in terms of the arrangement of services, right? And when you do the, say, client onboarding, do you say face-to-face meet with the client, or you do it over, say, WeChat or other, say, channel? Then will depend on the different type of risk to consider the risk level of a particular client. So country risk is one of the risks, right? We also need to consider customer risk, delivery risk, and also product or service risk, right? Apart from that, every institution must do a risk assessment in terms of the company, right? Say a bank need to do an institutional risk assessment of the risk of the bank, right? What sort of country are you in? What sort of customer do you accept? And what sort of products, etc., right? So in general, the regulators require institutional risk assessment to be performed every 2 years, at least every 2 years, right? Okay, risk-based approach means higher risk, you do more work, right? To understand the background of customers. And basically it's proportionate control and oversight, right? And how much you need to do depending on the risk level of the customer. And you also need to keep record and the relevant documents on file so that when supervisors, i.e. SFC, HKMA come to come to your office to do the inspection, you need to show the document to them immediately, right? While I was working in the SFC when we do inspection, and the key is that you need to be very confident as to what you have done, whether you comply with the law, whether you understand what is expected from an institutional perspective, what is required from an employee or staff perspective, right? And how the management ensure that all the staff understand their obligation, right? And as I mentioned earlier, policies and procedure, whether that has been established, is that comprehensive, right? Customer due diligence, the AMLO require customer due diligence and record keeping, right? Customer due diligence, basically when you open an account, you need to do customer due diligence. When you do occasional transaction equal to or exceeding 120,000, you need to do CDD. Wire transfer exceeding or equal to 8,000, CDD is required. Apart from that, when you suspect there might be potential money laundering or terrorist financing, then you need to do another CDD, right? And in a nutshell, when you doubt the veracity or adequacy of information provided by your client or you have previously obtained is not, say, accurate or up to date, then you need to do CDD again. And you need to document your CDD on file, making sure that when the regulator comes, you will be able to provide them. And apart from getting information from customer, you also need to use external or internal reliable independent source, right? Say, for example, some databases or just use, say, basic Google search, etc., right? And you need to identify the beneficial owner, right? We have learned that. And you need to use a risk-based approach. And you need to understand the purpose and the nature of the relationship and to verify the customer's personal identity, right? And if it is talking about a company, then you need to understand who is going to sign checks on behalf of the company, who is going to be authorizing the act of the company, right? And you need to verify their identity, understand who they are, what capacity are they having. Now, so basically you need to complete CDD before or during the course of a business relationship or before conducting the transaction. But the government also understand that sometimes banking transaction needs to be done very swiftly. So in exceptional circumstances, you need to verify the identity. But if you can ensure, i.e. your responsible officer or the senior management can confirm that the relationship is a normal conduct, and if after completion of all the checking, it would affect the business of the transaction, and that the risk of money laundering or terrorist activity is effectively managed, i.e. the management need to sign, confirm, and approve the transaction if the verification has not been completed before the transaction, i.e. the client want the transaction to be done very quickly. If you understand that this is a normal risk and that everything in terms of the risk of money laundering and terrorist financing is effectively managed, the senior management need to sign and confirm and approve, right? And if there is any issue, they will be responsible, right? So in terms of customer due diligence for a company, a corporation, you need to find out the full name, right? Place of incorporation, certificate number, address, right? Business address, registered address, the name of directors, and verify on a risk-based approach, right? So always remember, risk-based approach is the basic steps and basic concept that you need to use, right? Otherwise you would be working from days and nights without completing all these verification procedures. And say documentation like a board resolution, certificate of incumbency. Certificate of incumbency is similar to a certificate showing the name of directors, shareholders of some, say, tax haven companies set up in tax haven, say, for example, BVI, Cayman Islands, right? Because you won't be able to find out who is in control of the company in Hong Kong, because if it is a BVI company, Hong Kong Companies Registry, you won't be able to get it, right? For Hong Kong company, you go to the company's registry to do the searches, but from overseas companies, you would need to get the certificate of incumbency from the client. For other documentation, the certificates of incorporation, board resolution, articles of association, memorandum, etc., as well as details of ownership structure, right? That's what you need to get before you, say, complete your CDD documentation. So locally or incorporated company, do a company search. Overseas, basically the certificate of incumbency is required. High-risk customers, you do enhanced customer due diligence. Low risk, you can do simplified customer due diligence. Say, for example, listed company, then you don't have to do too much CDD work. And in any event, ongoing customer due diligence is required for all customers, i.e. senior management need to be regulating or checking or monitoring the transactions of client, especially if we are talking about high-risk client. Senior management is designated to check their daily operation, daily transactions, and need to file a suspicious transaction if it is suspicious. So review the documentation from time to time, conduct scrutiny of transaction, identify any transactions that is complex, unusually large, unusual pattern, and have no apparent economic or lawful purpose, right? So a lot of work required from the senior management level. And actually, in terms of some of the banks and financial institutions, it is not possible to, because of the large volume of transaction, it's not possible to do it in a manual basis. So your role as a, say, IT analytic tools and IT analyst would be very useful for, say, financial institutions to monitor these money laundering or potential money laundering or irregular transactions, right? The key is that you need to understand there is no apparent economic or lawful purpose, right? You ask yourself, does it make economic sense, right? Say, for example, if a client is going to transfer the funds, but it is going to transfer the funds, convert it into different currencies without any reason. So you will ask yourself, does it make sense? Why does the client change the money from Hong Kong dollar to pound sterling, and then to US dollar, and then from say US dollar back to Hong Kong dollar? What is the purpose? Does it make economic sense, right? If it doesn't, then you need to ask question, and you need to check the pattern by using analytical tools, right? And quite a lot of banks nowadays are using quite a lot of analytical tools to help them to do these, right? And in any event, for customers who has not been physically present for identification purpose, or beneficial owner of a customer is known to be PEP, or beneficial owner is involved in high-risk situation, then they are subject to a minimum of annual review, i.e. you need to review the customer due diligence process. Has to be done, right? At least once every year. And for those high-risk customers. And the latest change in the law sets out in the AML guideline of the SFC, and it mentioned that if a financial institution has verified the identity of the customer on the basis of data or information provided by a digital identification system that is reliable and independent and recognized by relevant authority. Relevant authority is i.e. the SFC, HKMA, insurance authority, the government, right? In any event, if the digital identification system is reliable and independent, then you should not consider the client as high risk, because say, for example, IM Smart is developed by Hong Kong government. If you use IM Smart as the digital identification system, that would be considered as reliable, right? And in any event, the important thing is you need to establish an audit trail for fund moving through the financial institution, right? What is the purpose? What is the purpose? For the regulator to trace the destination to the source. If the investigator can trace the funds from destination to the source and can prove that the money is dirty money, then they can confiscate the asset, right? i.e. a car, a security bank account, a house, etc., right? Customer record. Now, we said that AMLO require two obligation from companies, regulated industry, as well as their employee, right? The important thing is customer due diligence and record keeping. And record must be kept 5 years beginning on the day on which the business relationship ends, right? This is the requirement of the law. And the transaction record must be kept for a period of 5 years beginning on the day the transaction is completed, right? So if you don't have proper record keeping, you will be penalized by the regulators. Now, a lot of the banks, regulated industry, they will have a money laundering reporting officer, right? So that the staff understand whenever there are suspicious transactions, they can report to the money laundering reporting officer. And at the end of the day, money laundering reporting officer is going to report it to the JFIU, right? Joint Financial Intelligence Unit in Hong Kong. And in any event, the staff need to keep and ensure that they understand what is the suspicion, and also ensure that the documentation is provided to the money laundering reporting officer, so that the money laundering reporting officer can review and then provide the suspicious transaction report details to the government. And financial institutions or the regulated industry must establish and maintain a record of all STR, suspicious transaction records, made to the JFIU. And when I was doing the AML inspection on behalf of the regulator, we will inspect these SDR records, making sure that they have a proper record of all transactions that was reported to the JFIU. Why is that? Because the JFIU need additional information. They will need to come back to and then further investigate. And also, apart from that, the regulators, say HKMA, SFC, may also need to investigate further in terms of the customer, etc. Right? Examples that might give rise to suspicion, say, for example, the source of fund is unclear and not consistent with the customer's apparent standing. Say, for example, if your customer is a student, right? Okay, a student. Then in terms of the profile, in terms of the CDD, you will ask your customer, say, how much funds do you have, right? And what is the source of the fund, right? So if you open a bank account, you will tell them maybe, I got the money from my mom, right? My mom remitted the money to me, and I will use the money for tuition, school, university tuition, okay? So why do you need to open the bank account, right? What is the purpose for the bank account? What sort of service you want to get from the bank, right? Say, for example, just remittance, just payment of school fees, right? Anything else? Oh, I may want to buy some shares, right? Okay, what sort of shares do you want to buy? Maybe China Mobile, maybe HSBC, maybe other blue chip stock. Okay, how much money are you going to spend in terms of security trading? Maybe 10,000. Just a small sum. Okay, fine. That's your profile. That's the documentation on your CDD file, right? Okay, and suddenly the manager found out that there are 10 million money coming in from BVI to your account, and then you transfer the money to another account in Cayman Islands. Is that consistent with your profile? No. Then what the bank need to do, basically, to find out whether this is a suspicious transaction, and find out, say, probably checking with the client, with the student, hey, what is that amount? And is there any changes in your account, or is your account hacked, right? You need to find out, right? You need to find out, but not tipping off the client, right? Find out more. Once you get the information, fine, right? You then decide whether it is suspicious, right? Do you believe that this would be money from a dirty source? Would that be money laundering or potential terrorist financing, right? Then you decide whether you need to report, right? So that's the in a nutshell how it works, right? And AML training, as I mentioned before, all staff working in regulated industry, new staff, frontline staff, back office staff, managerial staff, and money laundering reporting officer, they need to go through AML training every year, right? Every year. And the record needs to be kept for 3 years. Just like one of your students work in a payment operator, right, which is licensed by the HKMA, you also need to go through the training. You also need to follow the AMLO to ensure that you have customer due diligence, you have proper record keeping, right? Now, let me share with you some of the update. Now, we mentioned that FATF go to different countries to do the evaluation, right? Actually, in September 2019, FATF came to Hong Kong and did the evaluation report. And this was not we have not a bad report. We have seen improvement from our previous report. And basically, Hong Kong is an international center. We need to follow the international standards. Some of the priorities, Hong Kong needs to ensure beneficial ownership created by non-professional trustees are readily available, right? And dealers in precious metal and stone need to be put into the AMLO requirement. And PEP definition is not very clear because it did not cover PEP from China. And then the designated non-financial businesses and profession is not too clear. And also, because of the Hong Kong is quite close to North Korea, and in Asia Pacific is an international hub. So the exposure to the terrorist risk, say by North Korea, is high. So we need to ensure that we have proper checking. And what the government has done in terms of PEP, the definition is not good. So we have the government has changed the definition, and the government has also extended the requirement of the AMLO, i.e. in relation to the obligation on customer due diligence and record keeping to the other non-financial businesses and profession, the DNFEP, right? And making sure that they are following all the requirement of the AMLO. So lawyers, accountants, estate agent, trust and service company service provider, when they engage in specified transactions, they need to ensure that they have proper CDD record, proper record keeping. And the latest change in terms of the AMLO is to also include the virtual asset service provider and money service provider, as well as registration requirement for precious metal and stone dealers. So different regulators regulate the different regulated industries. In terms of real estate agent, whenever they are buying and selling of real estate for clients, they need to follow the CDD and record keeping. Solicitors and accountants, whenever they manage bank accounts, securities account, and the client money, etc., signing of checks for clients, forming trust or company services, providing company services, then they also need to comply with the AMLO in that respect. And trust company, right? A lot of the trust company are being used by criminals in terms of laundering funds. And so trust companies and service providers also need to comply with the law. And so the latest change, as I mentioned before, is the virtual asset service provider, and also the precious metal and stones dealer. Now, I mentioned about politically exposed persons because the definition previously used by the Hong Kong government was not that comprehensive. And so we need to change it. And in any event, the basic concept is correct. An individual entrusted with prominent public function in a place outside Hong Kong, right? What you need to do is to impose a higher risk level on these PEP, right? And because they are considered as a channel for abuse of, say, using the PEP to, say, commit money laundering, etc., right? And very often, PEPs are not personally opening the bank account. Rather, their associate or their assistants are opening the account for these PEPs. So apart from say senior government official, their associates are also considered as PEP. Now that we have modified the terms, but they are the same, right? Domestic PEP, we change it to Hong Kong PEP, right? And the Hong Kong government also understand that sometimes when PEP say retired or resigned from the government, they will be considered as former PEP, and it will be unfair to put them as higher risk, right? So there is some flexibility in terms of former PEP, right? And in terms of beneficial ownership, the FATF is a bit concerned in terms of trust services. So in terms of trust services, trustee, beneficiary, and beneficiaries class are considered as high risk. And you need to arrange the CDD and record keeping requirement using a risk-based approach, right? I mentioned earlier, non-face-to-face originally is high risk, but now that if you use recognized digital identification system, it will not be considered as high risk, right? Dealers in precious metal and stone, the transaction period is until December this year. And there are two categories. One is category A, the other one is category B. And in terms of category B, they are dealing with cash transaction at a value of 120,000 or above. Then they need to register as Class B registrant, and they are subject to AML CFT supervision, i.e. they need to follow the AMLO and need to be, say, monitored by regulators. Virtual asset and virtual asset provider, right? Basically, I'm sure you have learned that from Vivian, so I don't need to talk too much about it. In any event, virtual asset is considered as a higher risk asset, right? So it is important to monitor it. And so with effect from 1st of June 2023, anyone who engages in virtual asset exchange business is required to obtain a license from the SFC, and they need to satisfy the AMLO on CDD and record keeping, and other requirements such as safe custody of client assets, and submit audited account financial information to SFC, and also allow the SFC to do inspection and investigation will also apply. Let me share with you some of the latest SFC enforcement cases on AML so that you would have a proper understanding of how it works and the view of the regulators, right? This is a case of Jinhui Futures, and the enforcement action was announced in February this year. Basically, Jinhui failed to properly assess and manage the AML and other risks associated with the use of CSS by its client, right? What is CSS? Basically, it is trading software developed by their client, right? What the SFC require is that you need to know your customer, right? And you need to know how you operate with the customer. And basically, the customer, there are 258 customers using the same CSS for placing orders. But the company, the regulator industry, Jinhui, failed to perform proper CDD on them and failed to understand how the system works. And that's why they were using these systems to manipulate the market. And in any event, Jinhui failed to identify PEP and tariffs because they are supposed to check the sanction list, right? The terrorist list, the PEP high risk list, right? As well as the money laundering risk, right? And quite a lot of them will be using, say, different systems. Some of them are performed internally, some of them are external database such as WorldCheck, the sort of common databases. But this company, they did not do that properly, and they did not identify PEP and terrorist. And it was for a long period of time, 2015 to 2018, right? And so the SFC want to send a strong deterrent message to the industry. And that's why they were reprimanded and fined 4.8 million. And their senior management, executive director and responsible officer, was banned from entering the industry for 6 months. And another responsible officer was suspended for 5 months, depending on their role in terms of the violation of the law, right? So the company is fine. The senior management was banned for a certain period, right? Another company, River Futures, right? This company also failed to carry out the AML monitoring, and it was reprimanded and fined 9 million. How come this is a fine of 9 million? Because this company has previously been disciplined by the SFC for similar AML failure. And this is the second time. That's why the fine is higher. And they failed to comply with the KYC, the know your customer requirement, the anti-money laundering and other requirement. And they failed to do the proper customer due diligence. And they also failed to do the two-factor authentication in their system. And they did not do a proper ongoing monitoring of the client's funds. And that's why the SFC want to send a strong message to the industry. China Everbright, it was last year in 2022. They have third-party fund deposits. And third-party fund deposit, third-party fund payment, third-party fund transfers are considered as suspicious transactions, but they fail to implement proper system and control to guard against third-party deposits. And they fail to identify and monitor the sub-account maintained by it with a local bank. Because quite a lot of the brokerages, when the SFC penalize them, they will say that, oh, the money went through a bank, so it is the bank's responsibility. So it is a wrong concept. A bank has their responsibility to do their work properly, but on the other hand, the licensed corporation also has the role to play. They have to do their own work in terms of AML responsibility, because they have the obligation to ensure that AML and CFT requirements are properly carried out. So they were reprimanded and fined 3.8 million. Sino-Rich, also in relation to cash deposit and third-party fund transfer, because they did not mitigate the risk of money laundering and terrorist financing. And they processed 238 cash deposit and 269 third-party transfer amounting to over 900 million, right? And although red flags were identified, but they were not followed, and they did not report to JFIU. And so it was fined 7.2 million, and their CEO and RO was suspended for 10 months, and their responsible officer suspended for 7 months, right? And the SFC said that after the investigation, it was found out that basically because of senior management did not do their work properly to supervise the whole operation on AML and CFT control. And that's why they need to be personally penalized. BMI Securities, also, there were suspicious transactions. The company failed to identify suspicious transaction. They did not do proper inquiry when they see suspicious transactions, and they failed to identify the PEP, right? And so they were fined 3.7 million. Apart from that, their responsible officer, as well as money laundering reporting officer, Ms. Maggie Tang, was also suspended for 5.5 months because the SFC said that she failed to carry out the necessary work in terms of inquiry on suspicious transaction, and also did not establish a proper and adequate system in terms of combating AML and CFT, right? So, I would like you to group with your classmates. We will have 1, 2, 3, 4, 5, 6, 7. Shall we have 7 groups? We have the front part of group 1. Group 1 here, and then at the back, group 2, and group 3 here, and from the slide onward, group 4, from you, from the slide, group 4. Group 5, and group 5. You want to join them as well? No? Okay, group 6 here, and group 7, you have a bigger group. Okay, so 7 groups. Now that we have learned the requirement of anti-money laundering, right? We have learned money laundering. We understand what is required, right? And let's have a look. We have a case study here. And I would like you to work together with your teammate and discuss this. And there are 3 questions. And I want you to work together, and maybe we can take a break of 10 minutes. We can take a break of 10 minutes, and then you can discuss with your classmates, and then we can have your group presentation in class. Tell us the answer to these 3 questions. You can choose a representative from your group, or if you want the whole group to come out and tell us what you have discussed and the answer to these 3 questions, that is fine. Clear? Clear? Okay. So basically, one day, Mr. Workman visited your bank. So you work in a bank, right? And he requested to open a corporate account for a company, Good Future Company Limited. And the beneficial owner, you asked who is the beneficial owner, right? You have learned all these AML requirements. Who's the beneficial owner? He said, beneficial owner is Peter. And then you will ask, right? For beneficial owner, you need to ask who the beneficial owner is, right? Background information. And he said, Peter is employed as the procurement specialist by the government of an East African country under a World Bank funded project, right? So he worked for the government of an East African country, right? And basically his duty include assisting the implementing partner agency in preparing the terms of reference, bidding document, advertisement, receiving bids, and conducting evaluation of the submitting bids, right? And then prepare the contract for successful bidder. So he is involved in the whole bidding process, right? He worked in the government, right? And he is evaluating submitted bids, right? So he is a bit senior, right? And he also evaluate the submitted bids and then prepare the contract for successful bidder, right? Okay, and you ask further information, right? How much is he earning, right? The source of fund, right? Source of wealth, right? And his annual remuneration is $120,000, right? Okay, then you said, fine, okay. Can you obtain further information? And apart from getting information from the customer, right? You also need to do some external checking, right? So you did a Google search and you also review the mass media, right? The newspaper, right? And you saw that Peter is redeveloping land at a cost of over $1 million recently, right? $1 million, that's quite substantial, right? And that's the information that you have obtained so far. You need to discuss with your colleagues, with your classmates, right? What kind of information or document will you request from Mr. Workman, right? Before establishing a new relationship with the company? What type of question you will ask Mr. Workman, right? The first one is what kind of information or document? And then the second question is what sort of question you will ask him in order to mitigate the risk of money laundering and terrorist financing, right? You will need to make inquiry, right? And then what are the questions that you will ask? And what about if Mr. Workman refuses to provide the information? What will you do? Will you open the account for him or reject him? And what's your plan? So just utilize what you have learned, discuss among yourselves. You can be creative, right? And you will discuss among yourself. And I would like you to come out to do the group presentation at 15:45, right? 11:45. 11:45. Then you will come out and do the presentation to the class and tell me what's the answer. Any question? Any question? If not, then you can discuss with your colleague. In Cantonese is fine, Mandarin is fine, up to you, right? And the final presentation should be in English. Okay? 3 more minutes. Have you chosen your representative? Not yet.
The question you get asked, so I think some of us, not only one will go out.
Good. Good, good. How about your group? Chosen a representative?
No.
No? You need to do it now.
Oh.
Otherwise, the whole group will come up.
We may just finish
You
up
get-
some of the questions
Mhm,
first.
mhm.
So we haven't choose.
You can say separate, say, you do question 1, you do question
Yeah,
2. Wow, you translate it. Who's going to do the presentation? You have chosen a representative? You need to decide who is going to give the talk. You ready?
Not yet.
Not yet?
Finish first.
2. Okay,
Now
Okay.
begin.
okay. You've chosen a representative? You better choose a representative. You can have 1 or 2 or 3 or the whole group, that's fine. For you? You ready? Oh, you translate the whole thing.
Yeah.
Using what? Google Translate? What about your group? You ready? You're the representative?
Yeah.
Okay. So you're ready?
Maybe.
10 more minutes?
Yeah.
Yeah, okay. You want to be the first group to come out?
Okay.
Okay, yeah. So 2 more minutes. You need to wrap up, please. One minute, 1 minute, please wrap up. Ready? Okay. Ready? You want to be the first group to come out? Yeah. Come on. What's that?
Okay, okay.
Okay, okay. So you're ready? Let us welcome group 7 first, right? Let us give a round of applause. Group 7, please come out. Please come out. Please come. So, please come out. What's your name?
You can call me Vincent.
Vincent.
Yeah.
Vincent. Yeah. And you?
My name is Jimmy.
Jimmy.
Jimmy. Joseph.
Joseph. Okay. So.
Actually, we are to making coffee.
Okay.
Yeah.
Okay. Sure.
Okay.
Okay. So, group 7, can you tell us what kind of information or documents that you will request Mr. Webman to provide?
The first type of documents should be the personal identification documents. Maybe his passport, national ID, or even a driver's license. And the second type is should be a proof of address. For example, the bank statements or residential lease agreement. And the third type maybe should be a business documents. For example, the certificate of incorporate or registration for the good future company. Yeah, that's for the first question.
Okay. What about the second question? What sort of questions that you can ask?
Wait a minute. Yeah. We think we should also ask him about the business activities. For example, his transactions, that help us to know an overview of the company's business activities, and including his business plan and the nature of transactions. And also maybe about the financial statements, including some maybe income statements and balance sheets to assess the company's financial health and activities. And the last, we think contracts and agreements.
Yeah.
Maybe some copies of the contracts and the agreements related to the company's business operations and transactions. That's for the second question.
What about if he refuses to provide some of the documents? Do we check it?
Yeah, maybe if he refuses to provide, maybe we should ask the bank to provide how to say sure. We think we should clearly document his refusal to provide specific documents and the reasons. Also, this documentation is essential for compliance and audit purpose. And second, we think the bank should communicate with this person and to understand the reasons. To know if he have any concerns or reservations that can be addressed. And the third, we should maybe take some risk assessment. We should conduct through a risk assessment based on the information available. Yeah. Okay.
Okay.
And that's all. Yeah.
Okay. Thank you very much, Group 7. How do you find it? Quite comprehensive, right? Quite comprehensive. And which group? Group 1. You want to tell us your answer? Group 1, please. For two of you,
Three
three?
questions. Three people.
Three questions. Two, one. Thank you. Tell us your name.
Hello everyone. My name is Yuan Ying.
Yuan Yuan.
My name is Liu Jiahao.
Simon.
I will be answering the first question. So first, we need to identify the identity of Mr. Workman. So we maybe need him to provide some ID card, or as the group 7 mentioned, the driver's license to approve his identity. Then we need more documents to verify that Mr. Workman has the authority of the Good Future Company Limited to our company to open an account. Then we need more documents about the company itself. First, what is the full name of the company and the date and place of the incorporation, also the address of the company, then the registration or incorporation number of the Good Future Company. Then we need to the certificate of incorporation of the company as well. And then we need more details about the ownership and the structure control of the company also, who is the beneficial owner of the company, and the detail of the beneficial owner, Peter, his identity as well. Then we maybe need more like details about other relevant documents, like data or information provided by a reliable and independent resource, like a third-party resource, and that we can know more about the company. Yeah.
Okay, let me answer the second question. I maybe will ask Mr. Workman to answer where the money to buy the redevelopment land comes from, because it see in the contract that it take many time to buy the land, use the salary in the contract. So are there any loan, and who gives the money to find out the resources of the money to buy the redevelopment land? And besides, the price of the land maybe also answered who make the price, and the price had been intentionally raised before to do the, because it's have the risk to do the money laundering.
First question. Yeah. So let me answer the first question. So if he cannot provide some of the documents, so we can still review the document that he provide, and so that we can evaluate the risk and see whether so if the missing document is not very important or related to some critical areas, so we can still evaluate it. The second thing is maybe we can ask our manager to make the decisions, because some risks that we cannot evaluate, so we need a higher level of the people to make the decisions and take the responsibility, or make the decision. And the last one is if we still cannot make the right decision, the safest way is we do not work with the customer, because if this way we just lost some profit, a very small amount of the profits only. But if we deal with the customer, if there are some problem happen, so it will relate to some policy breach, maybe affect the company reputation or the license or some very good punishment. So after evaluate the profits and the risk, so I don't suggest to let him open the account. Yeah, that's it. Thank you.
Wow, that's very good. And in terms of the first point, in terms of the documentation, they are very specific, right? They talk about the certificate of incumbency, the certificate of incorporation, right? That's very good. And in terms of the second point, regarding the types of questions, they well specifically ask them in terms of the piece of land, right? The development of the piece of land, and that is also a very good point, because if you see that there is something suspicious and it is in the, say, public media, it is possible for you to, say, ask the client or the potential client directly, and so as to clear some of your concerns, right? That's a good point too. And in terms of the third question, do you accept or reject, right? This group give a very good answer, i.e. you may ask your senior management, and well, you may need, depending on what sort of information that has not been provided, are they crucial or are they just minor questions, right? And you need to, say, communicate with the client, understand why they are unable to provide, right? And I think they give a very good answer. Let us give a round of applause to them. Thank you very much. Very good. Any other group want to supplement over your group? Group 3, please come out. Now let us give a round of applause to group 3, please. Group 3. Just supplement. Please come out, please come out. You have 3 representatives, right? Please come out here, in here. So tell us your name.
Well, my name is Huang Ruiming, and
Huang
I will answer the third question.
My name is Yang Qi, and I will answer the second question.
I'm Michael. I will answer the first question.
Okay. Yep. Please go. Please. Let me give you the mic.
Sorry. Yeah.
The first question is, what kind of information or document will you request, Mr. Workman?
Okay. For the first question, I think the first is to identify the customer and to check its if it is check its identity, like their ID cards, driver license, and record their name, the date or place or address of the corporations. And the second is to identify the beneficial owner and the one who come to the bank to open the account numbers, the relationship between them. Okay, and we need to obtain information on the purpose and the structure of the corporation, and the final is to verify this person's authority to on behalf of the beneficial owner. That's
I think the second question has to be divided into 2 parts, and the first part is about himself, and the second part is about the company he supposed to build. The first part, I will ask if I will check the statement of his own bank account and see if there is any suspicious about his statement, and if I found any thing special, I will ask what's the purpose of his trade, and I will check if I will check if it is he is the beneficial owner of his company. The second part is about his company's thing. I will firstly I will check if he has formed another company or he is another legal person. And secondly, I will check if he is related to any other companies of the market. And I will check if he is he has related to any securities listed on the market. That's all.
Well, okay, for the third question, if he just refused to provide the information, I think I will divide this into two parts. Well, for the first, it is to the third, right? I will just tell him two things. For the first, I should you should just explain the requirements that these fields are the necessary things that we need to for you steps. So he should provide these things, and this is the reasons. And second, we should just find more solutions for this for these things. For example, if he could provide us with more details of his money source of the buying, that will be more good. And the second is about the bank. They should just consider it more seriously about if it is okay to provide account for the company, and we should just give it more compliance management of this, so that it will be more safe for yeah.
Okay, thank you very much. Just hold on. Let me ask you a question, right? You said that you want to ask the source of fund, right? What are the specific question that you will ask?
How could you get the money? And because you could say that you just have that kind of number of your salary, but how could you afford that huge amount of money? You should just explain the details of it.
What about if we say it's none of your business?
Then I could tell this is our policy, that you should just follow it, or I will not give you the account.
Okay, so you will tell him that, wow, this is our policy. If you don't provide the information about your source of fund, I will not open the bank account for you, right? Maybe. Okay, so would you be also asking your supervisor for other areas, for such as other questions or other considerations?
Yeah, of course.
You will. Okay. Yep. Okay. So any other questions that you will ask Mr. Workman or Peter that you can think of? No? Okay. So this would give a very good answer and very interesting. Thank you very much. Thank you. Yep. Other groups want to come up? Yes, please. Tell us your name.
Oh, my name is Yang Shuxi.
Yang Shuxi. Zhou Mengmeng. Okay.
My name is Natasha.
Natasha.
Yeah.
Okay. Good.
I will answer first.
Close.
First, I will ask him to provide his ID card to check with his full name and some other individual information. And second, I will request him to provide the some information about the incorporation which he represents, such as the date and place of the incorporation and the registration or incorporation number and the registered office address in the place of the incorporation. And I need to record his the name of or direction of this incorporation and verify the identity of this directors. And I need him to provide more detailed documents and information about his incorporation, such as board resolution and certificate of the incorporations and memorandum and article of the association about he and the incorporation. And I need to ask him details of the ownership and structural control of the company, and such as a certificate of incumbency and so on.
Okay. What sort of question will you ask, Mr. Whitman?
I will ask him some questions about country risk, customer risk, and product risk evaluations. For the first one, the country risk, I found that Peter accepted the work in East Africa. Do you have some? I will ask Warman, do you have some financial translations and business relationships with those countries in blacklist or green list? And the second one is customer evaluation. I want to know what's your relationships between Peter and the workman. And I want to confirm whether you are real partnerships. And I also want to know why did Peter buy a land with over 1 million that he only has the salary of 120,000, do you know? Yes. And the third question is about company risk. The company, I want to know the company business and revenue and what's the purpose of this account. The fund results and the destination of funds. Yes.
If Mr. Workman refused to provide such a document, first I need to explain to him that our bank is follow the HKMA guideline. So we need to do some such kind of due diligence. Therefore, a list of documents need to be provided by customer. Maybe I can give him the list that every bank required first, then what kind of document he missed to provide. Then after explanation, I need to collect those documents if he already provided. For internal, do some maybe KYC or some internal evaluation first. Then I also maybe ask him to provide some document like any business, any BR like for another company that he and Peter is doing the same business nature financial statement or something to support him that the purpose of the establish this good future company in Hong Kong, to prove that this is a maybe is a legal company. It is one kind of the supporting document maybe he can provide, and so we will do this two-way step to tell the customer first. Yeah.
Thank you very much. They are very organized, right? Any question for them? Any question for them? No, no question for them. So if you are Mr. Workman, would you be, after listening to the points, because they are required by HKMA and to request all those documents and obtain information, and will you, as Mr. Workman, provide further information to them? Would you be persuaded? Yeah.
Yeah.
Yeah. Okay. So it means that you did a good job. Thank you very much. Thank you. They are very organized and very detailed in terms of the questions. So you've got the points in terms of answering the questions, and basically you have mentioned all the full name, the place of incorporation, getting the registration number, the certificate of incumbency, right? The latest financial information, latest annual return, address proof of directors, right? And you also asked different questions, say in terms of the due diligence that you have performed. You ask them the ownership structure, beneficial owners, right? The relationship between Mr. Workman and Peter. I think that's a good point, right? Because in any event, Mr. Workman is coming to see you, but not Peter, right? But Peter is the ultimate beneficial owner. Maybe you can ask Mr. Workman to arrange a call with Peter to find out more about whether the purpose of setting up the company and their relationship and the source of fund, etc. Right? And in any event, if they are convinced after you have discussed with them and they provide additional information, then that helps, right? If they refuse to provide information and after you have explained to them the requirement, and then you need to say escalate the matter to your senior management and see what you can do, right? Rather than simply, okay, let's open a bank account, because you need to actually find out, because the red flag is that Peter is working for the government of an East African country, right? You do not know which country, right? Whether they are on the blacklist or the gray list, right? And apart from that, he is a senior government official. You need to check whether he is a PEP, right? And so he is involved in terms of all these bidding processes. So that could be a potential opportunity for corruption, for bribery, right? So corruption and bribery is also a type of criminal activity. Any money transfer would be considered as money laundering, right? So you need to find out all these, and especially you see that Peter is developing a piece of land at a quite expensive amount, right? A large amount. So you need to ask them for the explanation, right? And I think that's very good. And in terms of examination, you may be asked to do an analysis in terms of what you can do and what you should do, what question you would ask, right? Especially in terms of high-risk customer, in terms of, say, source of funds, source of wealth. These are some of the basic questions that you need to ask, right? Okay, are there any questions? If not, then thank you very much for your time, and you need to give yourself a round of applause for your good participation in class and the good presentation. And well done. Thank you very much. I'll see you next time. Thank you. Bye-bye.